What if someone's resistant? This is, let's say I talk to you, Dad, and at this point you're like, no, I'm fine. Yeah, I don't have an issue with this. As an adult child, still a child in many ways, what should I, what do you do? How do you push back if the elder parent or elder individual loved one is sort of pushing back and saying, no, I'm fine? What would you suggest at that point?
Well, the first thing to say is, everybody's different. And all family dynamics are different. So there's clearly no, one size fits all. But, I really think it's, we always say we deal in reality. And for me, I really believe that's ingrained. I've been saying it for about 55 years as I've been doing this kind of planning, this kind of work. So, I understand that aging has issues, obviously. Memory can be compromised, obviously. So I think that I would be a little more open to it. I also did the Ulysses Clause. So you can see that I've taken proactive steps to acknowledge the possibility. Okay, but let's go with what you said. And let's say I'm resistant. If you see that if somebody out there sees their parent doing financially dangerous things, you have to intervene. And by the way, the beauty of doing appropriate estate planning documents is that you can utilize those documents and you don't have to go to court. God forbid, you have to go to court to set up a conservatorship. Legal fees, the intrusiveness of the courts.
Let me jump in there. And that's what happens if you don't have documents and if you don't get any cooperation, by the way. So if nobody can talk, if nobody's communicating, if a parent's really resisting and refuses to cooperate and is taking lots of bad steps, or sometimes we're really stuck. You have to go to court. You have to prove in public that your parent or your loved one has no capacity, doesn't have the ability to manage things. And that sucks. We don't want that to happen. That costs thousands of dollars. They have the right to challenge it. You might not even get it. The court oversees everything. So really what we're talking about here is what can you do to stay out of the courts ahead of time. So sorry, just wanted to flag that we don't want conservatorships. This is all about avoiding the Britney Spears style conservatorship.
One of our guiding principles in this law firm is to keep people out of the court system. And certainly the conservatorship comes up when there's a question of capacity. With younger folks, if it's special needs, sometimes a conservatorship is unavoidable. Sometimes with us older folks, a conservatorship is unavoidable. But again, with good planning, 95% of the time you can avoid that. If you're watching this, you're probably one of our clients. You may not be, or you may not be yet, but the documents we prepare are designed to take into account this possibility. So let's say again, let's go back to the question. I'm not buying it. I'm resisting. I'm just saying, yeah, hey, get out of here. I know what I'm doing. Well, the trust where the assets are held, it says that if two doctors, we take different approaches in different trusts. If two doctors, including my attending physician, indicate that I have lost the ability to manage money and make appropriate financial decisions, that I should be removed and no longer serve as trustee. And by the way, you'll notice that language that I just used didn't have some global conclusion about has dementia or lacks capacity. It's functional. It's can't manage the trust. That's what it's all about. If there's resistance, and if my doctor and a second doctor conclude that I really lack the ability to do it, you have the hammer. And I could theoretically get a lawyer and go to court to fight it, or go to another doctor and get a different opinion. Of course, all of those things can happen. But in real life, when this issue comes up and the kids or the next trustee intervenes because there's issues, I'll tell you, the issue tends to be resolved. Theoretically, many things could be done to make it complicated, but as a practical matter, it usually doesn't. Once those affirmative steps are taken to grapple with it, it becomes an issue that everybody has to acknowledge and resolve one way or another.
Cooperation ahead of time and communicating ahead of time and thinking about this ahead of time is just so crucial. Let's talk about the care side. Let's say that, so I think we talked about you need to have an estate plan in place. You have to have an up-to-date living trust, up-to-date power of attorney. Those are crucial where you name. We have sometimes clients when they are starting to lose capacity, they can see it themselves. They will voluntarily, as Mike, you talked about, name a co-trustee to step in with them. So they're saying, hey, I know I'm having issues. I don't want to lose all control. I'm going to name someone to step in with me, to step in to help me and to check my decisions as co-trustee. So they're not giving up the ability to make decisions. And you might, in your power of attorney document, say, I am giving someone the power right now. They don't have to show a doctor's note that I'm incapacitated to step in and help me. So getting that in place is great. What about from a care standpoint, though? Because that goes to at least a lot of financial decision making. But what if you're facing this and you're worried about, hey, how can I be taken care of? I know there's issues of isolation. You talked about Groucho Marx. Is there a story there?
Oh, there's a story there. Groucho is one of many individuals who apparently it's a very long, complicated story. But as I understand it, he had money, he had resources, and somebody who was close to him was taking care of him in his own home, and really isolated him from others. And what proceeded, as I understand it, as I read, was an enormous amount of financial abuse. He wasn't seeing other individuals. Nobody knew what was going on. And I've always been, frankly, kind of a critic of isolated luxury. We want to be very thoughtful about the decision about where are you going to live as you age, as we age. Many of us put the idea of staying at home on kind of a pedestal. We say, I want to be at home no matter what. Yeah, and for some that's fine, particularly if there's a community, if there's individuals who know you and you're still seeing people, or if you're a big family and they're coming around really often. But there's a lot to be said for being in a vibrant community, a continuing care retirement community where there's a lot of activities. So, how do you deal with it, and what kind of stimulation do you get? Because I do believe that makes a difference in terms of your acuity, keeping it going. I want to comment on something you mentioned just now, so we've got your trust where you have a successor trustee, right, to manage trust assets. You have the durable power of attorney where someone's empowered to manage like retirement accounts, assets that are not in the trust, and other areas. But what you alluded to was healthcare decision making. So let's emphasize that what you need to have, and I'm sure most do, you need to have an up-to-date advanced healthcare directive. And that's where you do two things. You name somebody you trust who's empowered to make healthcare decisions for you if you can't, and very importantly, to be an advocate for you, in the healthcare system. Second thing the document lets you do is be as clear as you want about how you want those decisions made. So you can be very explicit. Mine says, by the way, under no circumstances, if I'm in the hospital and can't communicate, no rap music. Not allowed. There's a lot of music I like. I think I say that as well. But I'm very clear about not wanting rap music in my room. And again, this goes to what kinds of issues could come up. And I'm going to do a sidebar here on younger people. Here's another issue that comes up all the time. So if you guys have teenagers, if you have younger kids or somebody in college or your grandparents, picture this. The kid goes off to college, is ill. You just find out your daughter is ill. You call up the infirmary to find out what the heck is going on because your daughter hasn't called you. They can't talk to you because of HIPAA, the Health Insurance Portability and Accountability Act. It has very strict privacy restrictions. So we've had clients shocked to call us and say, hey, they won't talk to me. Help us. So the point is that when your kids turn age 18, as we did with our kids, they should sign durable powers of attorney and advanced healthcare directives that include a HIPAA waiver. It's practical.
Extra important for you, and to make sure it's up to date, because if you face these dementia issues, we're talking about what if you're starting to lose capacity and you need people to step in and help you. You need to make sure your list is up to date as well. So even if you did an advanced healthcare directive a while ago and there's some family member who now is involved and they're not named in that, you need to make sure that they are added and that you make them an active agent, because as Mike said, your loved ones, even if they are involved in all parts of your life, if they are not named in a HIPAA waiver and an up-to-date advanced healthcare directive, they can't even talk to your doctors to get help, to get information, to look at your medical records. So I think and yes, of course, everybody over 18 needs this as well. For those of you who haven't subscribed to our Gilfix Law YouTube channel, please do so. Very easy. You can just point your phone at this or just Gilfix Law on YouTube. We have hundreds of thousands of views now. We're in the thousands of subscribers. We're really excited about that. This video will be there if it's not already. And for those of you who have not, so subscribe. Easy to find us. Gilfix.com, 650-493-8070. So thank you so much, and we'll see you guys again very soon. Take care.